Lady, resume with ground 4, in which the appellants say that the London judge was not entitled to conclude that the yacht was detained in March 2022 for reasons unconnected to the Secretary of State's public comments. And in that respect, we say that the judge was wrong, paragraph 69 of the judgment, and paragraph 90. Paragraph 69, just over halfway down the paragraph, where the judge says that the description friend of Putin, although wrong, was excusable political hyperbole. He then makes some further observations. And then paragraph 90, where the judge says the Secretary of State's connected with Putin remark in his media appearances had no mention in the ministerial submissions. He goes on, it was political messaging, didn't feature as a consideration in the Secretary of State's own decision making, and it made no difference to the outcome. A legal starting point that we refer to in our skeleton argument, but don't need to turn up, is that the knowledge of the department can't simply be imputed to the Secretary of State. That's the National Health Schools case. I don't imagine that's a controversial proposition. The submission to the Secretary of State in March 2022 contains no recommendation one way or the other. And as I highlighted earlier, it says to the Secretary of State that he can detain if he so wishes. For the court to note, that was a supplementary bundle, tab 21, page 161. I made the point at the time that the decision was taken personally by the Secretary of State, and the only record of his decision, of his taking the decision, is an email in the evening of the 28th of March, which records the words 179, the bundle. The Secretary of State commented that it's most certainly both in the public interest to detain the ship and to publicise the fact of its detention. He then goes on to say that he agrees that there's a comms opportunity. It was about 14 hours later that the Secretary of State gave a series of interviews on the quayside, in which he said that the yacht belonged to friends of President Putin who had made their money through their associations with President Putin and had deliberately masked their ownership by a complex ownership structure, and so on. That same day, and in the days that followed, there were exchanges between Department for Transport and Foreign Office officials saying that the Secretary of State was excited about Mr. Nemenko and wanted him to be designated. By implication, it's only an implication, but by implication, the Secretary of State thought that Mr. Nemenko was an involved person. And Mr. Driver is not able to add any direct insight into the Secretary of State's decision making. And I'll come back to Mr. Driver's statement in a moment in relation to the points that Lord Justice Singh very fairly put to me about that. Mr. Driver explains that decisions are sometimes spun in a particular way after they are made, but he can't disavow the Secretary of State's public statements. He says they don't fully reflect the reasons. That's as far as Mr. Driver can go. And the necessary implication, which the judge failed to draw, was that they reflected the reasons for the decision, at least in part. At that point, if I can invite the court to take up the judgment and just cast an eye down to paragraph 69, page 101 in the core bundle. And it's my submission that under the circumstances I've just summarised, the judge could not properly conclude that these comments were, as he put it, excusable political hyperbole, or, as he put it, paragraph 90, political messaging. Nor could the judge conclude or rely upon the fact that this was contrary to the basis of the Secretary of State's own decision. given the lack of evidence as to what that basis had in fact been, save for the media statements made by the Secretary of State that the judge disregarded. Where the judge said that the Secretary of State's statements were contrary to his own media briefing, and that briefing that we looked at this morning tells us nothing about the true reasons for the decision. And I remind the court that that briefing talks about making a clear and stark warning to Putin and his cronies. Now perhaps that is how a busy Secretary of State got the wrong end of the stick. But we don't know. And Mr. Driver cannot help us on that. Now, as regards Mr. Driver, whose witness statement is behind tab 3 of the bundle, and at page 62 of that bundle is the paragraph to which Lord Justice Singh drew my attention and the court's attention this morning. And the Lord referred to the final sentence of that.
Page?
Page 62. Yeah. Mr. Driver says the first detention decision and the second detention decision were not taken for any reasons other than those which were set out in writing in the 8th of April submission. Now, of course, at the time of the March decision, the April submission didn't exist. Obvious point. But the sentence before that final sentence is perhaps equally significant. Mr. Driver says the Secretary of State's media comments were framed in terms that would most effectively communicate the UK government's political messaging to the public and were, in any event, consistent with the rationale for the decision, which is set out more fully in the 8th of April submission. So when Mr. Driver is talking about what, as he understands it, is the reasoning that is set out in, reflected in, embodied in the 8th of April submission, he is saying that something that is consistent with that submission is what the Secretary of State said on the key side. He says that political messaging, however one chooses to characterise it, those words used by the Secretary of State were consistent with the rationale for the decision. So there are two possibilities there. Either, in April, the yacht was continued in detention and thereafter has continued in detention for the reasons that were given by the Secretary of State on the key side. Or he's wrong.
Who's wrong?
Mr. Driver is wrong. And the reasons are not, in fact, reflected in that 8th of April submission.
What if the reasons were that what the Secretary of State said was political wording that bore no relation to the reasons? So how does that affect anything?
Well, there are two conclusions that if one takes all of that together, one tries to square that circle, there are two conclusions that one can draw. One is that when he said those things, the Secretary of State meant them. And so he had based his decision on considerations that were irrelevant. That is one possibility. As I say, perhaps a busy Secretary of State reading that line in his media briefing about a friend of Putin, we know he'd seen similar lines and used similar lines in respect to Mr. Schvidler. Perhaps the Secretary of State got it wrong. Two and two together made 5. The other possibility is that the Secretary of State said those things, not believing them to be an accurate summary of the position, and that what was really going on was that this was that all directors having a media opportunity for some political advantage.
Well,
There's nothing in the
possibility is he made a mistake.
Well, if he made a mistake, Lord, and only that's a more attractive, more palatable conclusion to draw, then it's difficult to see how one can safely draw the conclusion that the Secretary of State made a mistake repeatedly, made the same mistake over and over again, multiple interviews on the quayside, but 14 hours previously had made a clear-sighted, accurate decision in which those comments played no part.
So, what I'm asking is, let's assume that the reasons that were in the written reasons are adequate reasons under the regulation for giving a direction. And the Secretary of State then goes out for whatever reason and says something that is not correct, right? How does that affect the validity of the reasons given earlier?
Lord, there aren't reasons given in substance.
Or the validity of the decision?
Lord, we say in that situation, one has to follow the analysis back. And that's the point that I was addressing a moment ago, that either the decision was taken the night before, reflecting those considerations which were wrong, or the night before, the Secretary of State, knowing full well that Mr. Nemenko was not a crony, was not a friend of
Then why is it not a misbehaving case where the reasons given do not prevent you looking at the real reasons even later and deciding whether they justify the decision?
Well, Lord, I'm going to come to misbehaving when we get on to proportionality.
I think at the moment, is this right, you're on pure domestic public law.
Lord, yes.
And in that context, judicial review is concerned about the contemporaneous reasons. And if one of them was legally irrelevant, then I follow your submission as a matter of principle that if a material reason which played a part in the decision-making process was legally irrelevant, that can be a ground for setting aside the decision.
It can be.
I see that, but there may be two difficulties in applying that in a purist way to the present case. One is that so far you're only addressing the validity of the March decision, but events then superseded that. We know that it was confirmed in April and confirmed again in January. So wouldn't it be of purely historic interest if you only succeed in challenging the March decision? And secondly, certainly something that's in my mind, and I'd be grateful for your assistance on this, is that suppose you're right on ground 4, and we accepted your argument. Normally what the Judicial Review Court then does is to quash the decision without retaking it. It's not for us, it's for the decision maker to retake it. But we know fully well what the decision would be. And this is why at paragraph 90, the judge below said that it wouldn't have affected the outcome. Why is he wrong about that?
Well, Lord, if I can perhaps take that in stages, and in stages is why I set out the decision-making in those 3 blocks, each decision, because Lord is, of course, right that one can look in a purist sense at one decision taken in March and come to a conclusion on that, but then thereafter say, but of course, a matter of a few days later, in the scheme of things, a different decision is reached on additional material and so on. I think the answer to that is this. Some of the same errors run through all of the decisions, and subsequent decisions in April and the following year do rely to a degree upon the first decision. As regards what would happen in reality if this court were to conclude that the decision was unlawful in March 2022, it had to be retaken. What one anticipates would happen is that the Secretary of State would read this court's judgment very carefully and identify what the errors had been, and in particular, when we get onto the proportionality ground, what the balance that properly falls to be struck is, and make a better decision. And of course, it's my submission that a better decision, a public law, lawful decision, certainly a better one than that was reached the first time, would be to release the ship. But even if that's wrong, even if that doesn't happen, then it may be that the detention, having been unlawful for a period, would sound in damages. It isn't a purely academic consequence.
It's a short period.
Well, that, of course, more depends on whether the court, in this hypothetical situation, were to conclude that the error had been rectified in April, or had been rectified only by the third decision.
Anyway, under ground 4, you say we should read back from what he said to his earlier decision making.
Yes.
Yeah.
I'll move on then to ground 3, in which we say that the learned judge was wrong at paragraph 56 of his judgment. He was not entitled to hold. The grounds for detention were stated fully enough in the March 2022 detention direction. He says, paragraph 56, if it had been necessary to address the claimant's challenge on a further ground, that there was a failure of the detention direction to state the grounds relied upon, I would have dismissed it. And he then goes on to make a comparison between the requirement to state the grounds in Regulation 57D and the requirement to provide a statement of reasons, one of those more stringent safeguards that applies in a designation case in Regulation 8.4. If we go to the regulations, so authorities, tab 4.
So you say grounds are equivalent to a statement of reasons?
No, we don't.
What do you say?
We say they're different. We say that a statement of grounds does not have to be as extensive as a statement of reasons, but it does have to have some content. I'll take the law to authority for that. Starting point is the regulation. Tab 4, page 166. Subparagraph 5, subsub C and D. Detention notice must state the grounds on which the ship is detained, and separately must state that it's given under this regulation. So from that we can see immediately that stating the grounds for detention is something different to, in my submission, more than merely rehearsing the power that it's given under. So they're two separate subparagraphs of requirement in the regulation. The detention notice we took from Supplemental Bundle 21, tab, page 165. And that, in my submission, satisfies the requirement to state that it's given under this regulation, it does no more than that. It gives no reasons for the exercise of the power. It says only why the power is believed to exist. Paragraph 5. Now, for why that's not good enough, Lord the Master of the Rolls question to me a moment ago in substance, Authorities tab 9, and I regret that the pagination is obscured in my copy, but I think it's page 257 in the electronic. Yeah. And this is a case about a school admissions appeal. And if the court goes forward to page 222, that's the internal pagination. It's 260 in the electronic. You see that between D and F, there's a decision of an appeal panel that's being challenged as insufficient. And over the page, so this is page 262, at H, you see how the complaint is put. There's merely a ritual incantation of the requisite two-stage test. And then onwards another page, 263 in the electronic, 225 internal, at F, we see what Mr. Justice Dyson, as he then was, had to say about that. He talks about authority. He says the minimum requirement of the grounds of a decision is that they explain broadly the basis of the decision. Statute requires broad grounds rather than detailed reasons. What is required will depend on the issues that have been raised. The basis of the decision. Not that there had been a decision, or why it was open to the decision maker to take a decision, but the substantive basis for the actual decision has in fact been made. So the appellants accept that this is a requirement to state grounds rather than provide reasons. There must be some content to those grounds. Now,
so which page are the reasons again? Which page are the reasons on that we're thinking about? You gave us the page number a second ago.
The Secretary of State's is
supplementary
22, page 179.
Yeah, 179.
And I think in fairness to my learned friend, the position as put would be that page 165, which is the detention notice, where that has the grounds for detention, that is the authoritative statement of what the grounds for detention are. And we all saw in the regulation there is a requirement stated on the face of the detention notice.
So you say that the fire is being detained on the grounds that it is owned, controlled or operated by Sergei Naumenko, a person connected with Russia, is not sufficient grounds.
Well, I do say that. I say that's a ritual incantation. That's stating what the provision is that gives rise to the power to make a detention. It's doing no more than that.
And what did the judge say about those words?
The judge said, firstly, that it wasn't necessary to address this ground of challenge. And he said the contrast in language of the two provisions, he was talking about detention designation, means that the detention direction does not require grounds to be equivalent to a statement of reasons. We respectfully agree.
Yeah.
We said it was still inadequate. Now, after the March decision, after the direction that was issued, there were efforts to rationalise this decision, to put together what might otherwise have gone into grounds for detention on a detention notice. None of that was there in March 2022. None of that appears on the face of the detention notice. So it's my submission that the judge, contrary to what he opens paragraph 56 by saying in his judgment, had to determine this issue, and that if he'd done so, applying South Gloucestershire, which was cited to him, he would have found that the grounds for detention were not adequately stated for a lawful detention. And insofar as the requirement under the regulations that appears on the face of the detention direction, that direction remains defective. Ground 5, as to which we say the judge was wrong at paragraph 82 of his judgment. And this is about the characterisation of the April 2022 decision as something other than a holding decision. This ground arises from the Tameside challenge pursued below. And in paragraph 82, the judge refers to the comment made by Mr. Robert Courts MP to the effect that he agreed, and this is if my lords wanted to knows my lord and my lady, forgive me, it's at supplementary bundle 33 221 is Mr. Courts, in which he says, maintain for now whilst we obtain further evidence. And the judge observes that the Secretary of State did not expressly share Mr. Court's view. What that doesn't address is the express terms of option A. I can invite the court to go back to the supplementary bundle, tab 32. Page 214. Options. Option A. Course of action that the Secretary of State selected. Maintain detention while seeking further evidence. That is the option that was put to the Secretary of State. That is the option that the Secretary of State took.
Could that have meant simply while seeking further evidence from the appellant side?
My lord, it could, and that possibility was explored in the course of submissions below, and without going through the extended correspondence, Lord saw briefly this morning. There's a letter on the 26th of May, so very shortly after the second decision,
yes,
which starts putting that material forwards, and it gets no attention at all of substance until the December time.
Well, that may or may not be right, but that would be a different complaint.
Lord, yes, it would, and I will come to that. So that's why we say that to reach the conclusion the judge did on this point, and that accordingly the detention after April 2022 was lawful. That's why we say that was wrong. So we say that the express basis on which the Secretary of State was recommended in the submission to maintain detention was while seeking further evidence. And one can understand that, given what at that stage is still the relatively sparse information available to the Secretary of State about Mr. Namenko as an individual. that brings me to ground one, in which we say that even if the judge was right about the reasons for the detention, he was nevertheless wrong to find that this was a proportionate use of the detention power. And this is in paragraphs 85 and 86 of the judgment, where we say the learned judge was wrong. In particular, in his treatment of Bank Mellat, the end of paragraph 85, and in how he approached my learned friend Mr. Pobjoy's submission, which he addresses in paragraph 86. The court will now be very familiar with the Bank Mellat four-stage analysis. We are concerned, as the appellants in this case, with limbs 2 and 4. Whether the measure is rationally connected to the objective, as to which we say it was not, even if the judge was right in his finding at paragraph 83 that the vessel was detained because Mr. Nemenko was connected with Russia and very wealthy. And on limb 4, whether a fair balance was struck between the contributions to the objective and the effects on the rights of those affected, we say not. The appellant's submission on the proportionality ground can be summarised as this: the means adopted, that is, detaining the vessel, had no sufficiently rational connection to the ends being pursued, and for that reason, the damage to the appellants wholly outweighed any benefit that could have been anticipated. I'll start with the rational connection. The appellants accept, of course, that sanctions measures can be rationally connected to a foreign policy objective, and that targeting non-state actors, businesses, private citizens in Russia, for example, could contribute to changing Russian behaviour. Freezing the assets or detaining the yacht of someone who's built infrastructure in Russian-occupied Crimea to consolidate their control. Bans on the export of dual-use technology. Closing British ports to Russian ships so that some products manufactured here become unavailable to ordinary members of the public in Russia. Where you have a broad sectoral measure, a phrase that the learned judge picked up from that letter from Lord Panic, 2017, where you have a broad sectoral measure, general application, there will be people caught by that measure who you wouldn't sanction individually. But they get swept up, and the measure is nonetheless proportionate. So it's rational to impose a measure that catches astronomical telescopes because it also catches night sights for sniper rifles. That sort of broad effect, when you say that in the round it's rationally connected, and then you go on to think about a fair balance. But this case isn't like that. Mr. Nemenko hasn't done anything in Ukraine or been associated with anyone who has. Nobody suggests otherwise. So far as we're aware, there isn't a wider policy to detain each and every Russian yacht that the government can. The detention of the fee isn't like closing ports to all Russian ships. The measure in issue, this direction, is particular to this one yacht. It's a specific exercise of a permissive power provided in the regulations. That's what falls to be analysed in the Bank Mellat test. This is the point that the court looked at previously in misbehaviour, paragraph 25. That's at authorities at 19.865. end of that paragraph, D. Court must always keep in mind that it is not concerned with generalities about the legislation in question, but with whether the effect of the exercise of statutory powers in particular circumstances is in fact compatible with convention rights of the applicant, in that case to a council for a licence. So it's essential that the court looks at whether the effect can be rationally connected to the objective. The appellants haven't sought to challenge, as I said in opening, the underlying legislation. The corollary of that, in my submission, is that the respondent can't simply say our sanctions regime has positive effects that outweigh the inconvenience to the appellants. The question is whether the detention of the fee has positive effects that outweigh the inconvenience to the appellants. And what the court is asked to do is the exacting analysis that Lord Sumption referred to in Bank Mellat, paragraph 20. Generalisations, speculative propositions, that's perhaps how my friend Lord Anderson put it, won't be enough. The margin of discretion is just that, it's a margin. I'll illustrate what I mean by that in two ways. Firstly, Authorities Bundle tab 43, page 1983. This is the Schvidler judgment. And I apologise if the court is marking a copy in a core bundle from the other appeals. This is the version of the Authorities Bundle. So on page 1983, 92 paragraph. And Mr. Justice Garnham there says, limb 2 of Bank Mellat, it's about halfway down the paragraph, is not entirely a question of United Kingdom foreign policy on which the court is unqualified to form a view, nor is it a subject on which the court should necessarily be slated to interfere on grounds of institutional competence. The Secretary of State is the primary decision maker under the statute. The court is well placed to judge the reasonableness of his analysis. That's an instance of the point that I made at the very beginning of my submissions in the A case. It's a question of characterising the question that's before the court. Here there is a legal question linked to Bank Mellat. Is there a rational connection? And the court is well able to answer that. Now, of course, whether Mr. Justice Garnham applied that principle correctly is a matter between Malone and Friends and the other appeal. We respectfully say that puts the principle very well, especially on the institutional competence point. That line through the authorities, our role, quoting Raymond, and so on. Specialist expertise and democratic accountability. That's the basis for the institutional competence analysis. Neither of those points bites very hard in this context. As regards expertise, we've seen the analysis on what this might contribute. Comes late, it's put in generic terms. It doesn't draw upon diplomatic telegrams from the embassy in Moscow. It doesn't draw upon reporting from the security and intelligence agencies as to what's going on inside the Kremlin. And this isn't a case on the democratic accountability point, where the court may say to itself, well, if we don't accept the Secretary of State's position and something terrible follows, how would there be accountability? What's at stake here is the detention of a single yacht, which means a great deal to the appellants, nothing of any real substance as far as UK policy is concerned. If I could ask the court to go to Bank Mellat, Authorities at tab 27, page 1430. And we pick up at paragraph 74. And we have Lord Reed's formulation. Let's see. In essence,
Sorry, I missed the page and the paragraph number. Could you help me?
1430.
Yeah.
And it's paragraph 74.
Thank you.
And this goes on to step 4, which I'll come to in a moment. Whether balancing the severity of the measure's effects on the rights of the persons to whom it applies against the importance of the objective. In Bank Mellat itself, the court didn't try to determine the merits of the UK's foreign policy towards Iran. It did ask how sanctioning one particular Iranian bank was logically capable of having a material effect on the Iranian nuclear programme when other banks were not being sanctioned. It's paragraph 27 for the court's note. We don't need to go to it now, we spent some time on it, I think, in the other appeal. Lord Sumption looks carefully at the situation. He concludes that it wasn't having a material effect, it wasn't rationally connected, and the exercise of the power was therefore arbitrary. Now, the factual situation is not exactly the same in this case, because it isn't the position that the UK government could detain every Russian yacht that it wanted to tomorrow, and was only detained with a fee. On the other hand, what the UK government has been able to do, and has done, is to close British ports to every Russian yacht and every other Russian ship. So there has to be a rational connection between this measure and the aim of getting Russia to cease its hostile actions in Ukraine. The aim isn't to send a message, that's a means, not an end. And the judge seems to have been satisfied with a rational connection between the overall sanctions regime and the aim being pursued. And we say that's wrong.
If there had been 10 ships in UK waters and Secretary of State only detained one, then I can see the suggested analogy with Bank Mellat. But if you detain all the ones that are actually in UK waters, but there only happens to be one or two, then why is that not rationally connected to its aim?
Well, I think the question that arises then, Lord, is the extent of the contribution that can realistically be made to the objective. It may be that shades over into limb 4.
Yes, well, I can see that. I can see that argument. But at the moment, I must confess, I'm having difficulty in understanding your submission that the means chosen simply have no rational connection to their aim.
Well, one answer to that is that the measure that is taken is specific to the fee, as it necessarily has to be. But that is the measure that the court is considering. And there aren't 10 other Russian ships. I mean, in fact, what we don't know is the extent to which other Russian ships have or have not come and gone in the period since the fee was first detained. But if they have, that takes you rather towards Lord Master of the Rolls sort of line of thinking about whether there's some significance to this being an iconic vessel or something of that sort. But we don't know. Now, as to what we have on that rational connection. I took the court through the March and April submissions earlier, in which there was, as I drew the court's attention to, there was no consideration as to the purpose underlying the regulations and how this was going to contribute to it. The court turns up in Supplemental Bundle tab 46, page 297. Paragraph 6. This is the rationale annex. Now, paragraph 6, second line, officials cannot attribute the strategy of asset detention to direct effect on the regime. And then paragraph 7 deals specifically with this detention. It says it was thought that through the material impact of having his vessel detained, it was thought Mr. Nemenko may respond by criticising the Putin government. This has not occurred. It is unlikely to, as he maintains he's no connection between him and the regime. So we respectfully say that the judge was wrong in his application of Bank Mellat. And we make 5 short points on that. The first point is that there is a close analogy between this case, though not an exact one, but a close analogy between this case and Bank Mellat. Here, one Russian-owned yacht is affected. In that case, one Iranian bank is affected. So when the learned judge seeks to draw a distinction between those two cases, at the end of paragraph 85, we say that distinction isn't really there. Second, we say that when the judge accepted the submission, the Secretary of State didn't need to demonstrate the efficacy of each individual detention or designation in order to maintain sanctions measure. We make the point that the relevant measure was this detention, just as it was the direction made in respect of one Iranian bank in Bank Mellat. Parliament did not approve detention of Russian vessels at large. It gave a power for the Secretary of State to make reasonable decisions within the bounds set by the legislation and governed by proportionality to do that. Third, we say that it was necessary to demonstrate the rational connection between a detention and the objective pursuit. And in practice, efficacy would be an important aspect of that. And the judge said at paragraph 86, about halfway down, that's not an issue for the court. In the end, all that's needed is a rational connection. And on to my submission, that's simply wrong as a matter of law. This is paradigmatically linked to a Bank Mellat, an issue for the court, misbehaving. Four, the judge's answer seems to have been that the Secretary of State has a broad margin of discretion in a case such as this to decide that the exercise of the statutory powers is needed. That's the end of paragraph 86. And we say that's wrong. And Mr. Justice Garland correctly identified the proper approach in Schvidler. And the question isn't about whether the exercise was needed, but rather whether it was rational. That's a question for the court. Fifth, the nub of the judge's thinking, what seems to be driving the conclusions in 85 and 86, it is, in my submission, at 84, where the judge says, towards the end of the paragraph, 4 lines up, it's rational to consider that Mr. Nemenko is the sort of individual economic actor on whom sanctions could achieve the broad and deep impact which Parliament intended by the connected with Russia powers, and so on. What that seems to come to saying is that one wealthy Russian is as good as another, at least if they own a yacht. Now, that's an analysis that needs to be scrutinised closely, not least in light of Mr. Driver's evidence about how decisions are made on a case-by-case basis, evaluating specific factual circumstances.
And in the light of the fact that the evidence was that his wealth could not have been obtained in the ordinary course of business.
I don't think it said it couldn't have been obtained in the ordinary course of business.
Well, I'm summarising and I can't remember the precise words, but I drew your attention to them when you looked at Mr. Driver. He said it wasn't an ordinary businessman's wealth.
Well, I will check that, if I may.
Well, we can check it now.
The rule has the paragraph in mind.
About page 69, I think.
It's 69. I would say page 69.
About, yeah.
Bottom of the It may be that I'm at cross purposes with Rule. I had taken Rule to be suggesting that there was something somehow untoward about the way in which.
Yes.
Well.
Significantly beyond that acquired in the ordinary course of business.
Well, that begs the question of the ordinary course of business of who? He's an extremely successful businessman. He's plainly obtained a level of wealth that's beyond that will be obtained in the ordinary course of some other business generally.
Okay, well,
very briefly on the respondent's notice point, we can take that from the judgment, paragraph 84. The judge said he didn't need to rely upon what Mr. Driver said about Russia's political economy, and the respondent says that the court can and should rely on that. In my submission, there is a limit to the useful evidence that Mr. Driver can possibly provide on that point. He is a civil servant working in maritime security. There's no indication that he's an expert on Russia's political economy. And the judge was right when he decided not to rely upon it. And even if it was relied upon, it's entirely generic about the typical wealthy Russian. And if it's helpful at this point, I can give Maraud and Milady references as to what is in evidence about Mr. Nemenko's wealth. And that is supplemental bundle at tab 5, page 93. Is where it begins. That's the second witness statement, Mr. Incolette. And it's paragraphs 11 onwards. The fair balance then. The lack of a rational connection in limit 2 of Bank Melat, in my submission, is fatal to an overall fair balance and proportionality. So the detention fails on limit 4 of Bank Melat for the same reasons that I've just described. Limb 4 question is not as purely legal as Limb 2. And the margin of discretion might, in principle, make a difference here. But for the reasons I've given, it's my submission, it's not a finely balanced question. I'll make just 3 further points on the fair balance. First, if and insofar as the April 2022 detention was intended to be a holding decision for further evidence satisfying Tameside, which was not then sought. That is a further indication that the detention was or became disproportionate. Second, the disproportionality has become more acute over time. There is extensive evidence in the witness statements of Captain Guy Booth about the deleterious effect of an extended London berth on the yacht. References, just for the court's note, supplemental bundle tab 1 is Captain Booth's first statement, paragraphs 23 to 24, that statement. And in his second statement, which is at tab 4, beginning at page 85 of the supplemental bundle, paragraphs 10 to 13. And there are also those attachments to the letter of the 1st of December, which is in supplemental bundle tab 45, page 282. I can summarise the issues quite quickly. The yacht came here direct from the builders. There was a lot of follow-up work, snagging to be done, particularly electrical work, which is safety critical. It should have been under warranty, but the warranty has expired with the yacht in detention. That work will now be done at the appellant's expense. The berthing conditions were unsuitable, with issues ranging from intruders to fire safety to a collision to rust formation as a result of nearby construction work. So the yacht's physical condition, and thus the effect of detention on its owners' A1P1 rights, worsen over time. 2 years after completion, the yacht is no longer state of the art, so its chartering value has been reduced. The appellants have been unable to get protection and indemnity insurance for the yacht because brokers and insurers won't deal with a ship that is detained under sanctions regulation. Echoes there of Mr. Schvidler's difficulty trying to explain his position to his children's school. It's not eliciting quite the same instinctive sympathy, but nonetheless very real. In the December 2022 submission, acknowledged some of those issues. Supplemental bundle 46, page 298, paragraphs 14 to 16. Over a year ago, and they were acute then. Despite this, despite very extensive correspondence from the appellants, the Secretary of State has declined to allow the yacht to relocate to a more suitable berth in the UK. Months have gone by in which letters went unanswered. Move was planned last summer, apparently not endorsed by the Secretary of State. Less than a week before this hearing, the government finally re-engaged and said that berthing at Southampton, where there was a proposal to move to last year, would risk the yacht with its British crew absconding. So if it went there to be repaired and kept in better conditions, it would have to be rendered immovable. Clear how that would be safely achieved. Further, how it would be achieved without some, at least potentially further impact on the A1P1 rights.
How do these more recent developments have a bearing on the legality of the decisions under challenge in these proceedings?
The Lord is looking at a series of decisions which have been subject to a challenge, and we would accept that the most recent decision is the December submission, is the January challenge. But at that point, it's made very clear that these are issues that have developed, that are continuing to develop and will worsen over time. So it can hardly be said that the Secretary of State has been ambushed by these developments.
No, it's not a question of ambush. I'm just wondering what the question for this court is. Surely the question for this court is whether the judge below was right or wrong in dismissing the claim for review, which he did. And that in turn depends depends, at least under this limb of the challenge, on whether he was wrong to conclude there was no breach of A1P1 at the time of the decision.
Yes. Oh, yes. And of course, the judgment necessarily doesn't record every detail of the submissions that were made. But I would accept that, of course, as a matter of principle. And so, if one goes to the government's case at its highest, that is Mr. Driver's evidence on the political economy and how this may have some effect. It may put some force on some lever somewhere in Russia. Well, that comes to this, that any individual with substantial wealth in Russia who pays their taxes, doesn't leave the country or publicly criticise the regime, is a legitimate target for what in substance is freezing assets, so long as those assets are ships or aircraft. That's even if that individual has no power or influence or connections and has done nothing to endorse the regime or its policies. And that, in my submission, is indicative that the Secretary of State failed to grapple properly with the fair balance, and that the learned judge, with respect, did not correct that balance. Ground 6, in the, I think I have 12 minutes left. This is conversion, private law. The judge ought to have held that the unlawful detention of an asset in this way was sufficient to constitute conversion. And here we say the judge was wrong, paragraph 91, and in particular wrong in his analysis of the key authority, which is the Van Gogh judgment of Mr. Justice Flo. Now, this ground only arises if the appellants succeed in showing that detention was unlawful. And the respondents say, even if it was, even if that were the case, there's still no claim in conversion. And the judge agreed with them. Conversion, of course, unauthorised dealing with goods so as to question or deny an owner's title. It includes when a defendant, without physically interfering with the chattel, wrongly denies access to it, to the claimant. We take up the Van Gogh, which is in tab 21 of the authorities bundle, behind page 942. And this is a case about the use of a detention notice under powers from the Merchant Shipping Act 1995 to detain a ship that was said to be dangerously unsafe because of an outbreak of norovirus. The 1995 Act enabled the making of safety regulations, and such regulations as were made included a power of detention. Page 949, paragraph 17, records that provision. If the court turns back to paragraph 7, you'll see this being dealt with as a preliminary issue. It proceeds on certain assumed facts. So it proceeds on the basis in paragraph 7 that the court is to assume that at the time that he issued the detention notice, which I refer to as the first notice, Captain Rudge was satisfied with the matters set out at those paragraphs of the defence, which can be summarised as follows. And then at E, in the margin, the minimum reasonably practical steps that were necessary to ensure that the environment on board would be safe and without risk to health were that the ship remain in port for 48 hours. So the assumed basis for the detention notice being considered was that it would have effect for 48 hours. We can then go straight to the punchline, which is in paragraph 53. I'll just invite the court to read paragraph 53. It's at page 958. The judge says the intention of the detention notice was merely to prevent the claimant from using the ship in a particular way. That's for the third main cruise for a short period of time. That was not conversion. My first submission is simply this. With that reference to a short period of time, this judgment is not authority for the proposition that preventing the use of a ship in a particular way for a lengthy period of time will not constitute conversion. And that's in substance the principle that Sir Ross Cranston took. We can see that paragraph 91 of the judgment. The judge says that when Flo J referred to a relatively short period of time, that was not part of his reasoning. Of course, Flo J didn't say relatively, he said short. He wasn't making any comparison with a longer period of time. And he was expressly asked to consider the question of the 48-hour detention. That is as far, in my submission, as the Van Gogh goes. And one can compare the position here, where the yacht has been detained for almost 2 years, where the detention is open-ended until Russia withdraws from Ukraine, perhaps until reparations have been paid. When we're not concerned with a 6-day cruise, with 2 summer seasons already missed, and where the yacht has suffered serious deterioration.
Mr. Berthel, I'm sorry to interrupt you. I may have misunderstood the judge's reasoning. But I had read paragraph 91 as saying in the last sentence that the duration of the detention was simply not part of Mr. Justice Flo's reasoning as to the existence or otherwise of conversion, and that the ratio of that case, in the view of Sir Ross Cranston, is in the preceding sentence. He decided that this did not constitute the assumption of ownership or dominion to amount to conversion. He may or may not be right whether you need to have assumption of ownership or dominion for it to amount to conversion, but have I understood what the judge is saying?
Well, it's difficult to be certain in answer to that, because what one has is 2 points. We have is it the relatively short period of time that's not determinative here, yeah. or is it something broader than that?
But how does it help to construe a first instance decision in a completely different case as a deed? Is it not that you have to show that in Lord Nichols' judgment in Kuwait Airways, the conduct was so extensive that an encroachment on the rights of the owner so as to exclude him from the use and possession of the goods? That's what you have to show. That's the third requirement given by Lord Nichols in Kuwait Airways, which remains, as far as I understand it, good law.
My Lord, yes.
Right.
So, and can I assist my Lord with that? So, I'll give you the direct answer on Kuwait Airways, as I'm conscious I'm 3 minutes away now from Sir James's time. The point that my learned friends make in their skeleton argument is that what you get from Kuwait Airways is that this is about the degree of encroachment. Paragraph 39 of Kuwait Airways, we don't need to go to it. Yeah. And in response to that, the appellants say 3 things. Firstly, the degree of encroachment is very significant, not least because this insistence on keeping the yacht in London is having a deleterious effect on its condition. To that extent, there is a parallel with the earlier authority of Howard and Perry. There's a case about malleable steel being stuck in somebody's rail yard.
Would you say that the acts of Her Majesty's government became conversion at some particular point in time after the original notice?
I think that's a question that would go. Maybe that's a question that goes to quantum rather than liability.
I don't think so. I think you have to say that conversion takes place at a certain time. I mean, if I come in your house and steal a book from your bookshelf, I convert that book when I take it off the shelf.
Well, then in that case, the answer is that it happens at the moment that the detention notice is made, where it's intended at that point that this is going to be an indefinite detention.
That's what you say.
Yes. Yeah. At the moment, the crew have physical possession, but the owners do not have use of it.
Okay. You had two other points.
Second, we don't understand, and this is the point that Lord, I think, has just put to me. The respondents have said that detention is not indefinite because it can be reversed at any point.
Temporary and reversible.
And the point is that nobody has any indication of when such a reversal might happen. And that it's expressly stated in the decision documents that this is going to be an indefinite detention. My third point is simply this, that duration, which is already very considerable, can simply be considered to be an aspect of the encroachment principle that's identified in Q8 Airways. Well, I could just take my lord and my lady to I don't think it's the only thing you said. Lords, my lady, unless I can assist the court further, I'm going to turn my back and ask what I've missed. Unless I can assist the court further, close my submission.
Thank you very much, Mr. Bailey. Sir James.
Lord, my lady, I'm going to do Schvidler first, so to revert to that, if I may, and then do the Dalston case second. Just so you know where we're going and who's going to be making submissions about what, I am going to do all of Schvidler. Then I'm going to do proportionality in relation to Dalston. And then, friend, with your permission, Mr. Pobjoy is then going to deal with grounds 2, 3, 4 and 5, so improper purpose, the reasons and so on, in relation to Dalston. And then the resident expert on our team in relation to conversion is Miss Plews, and she's going to be dealing with ground 6 at the end, if that's acceptable. So that's going to be the division of labour. Back to Schvidler, if I may, two initial points. First of all, there has been, in fact, and it follows a statutory scheme, careful and very careful consideration of Mr. Schvidler's case by the government. As you know, SAMLA provides for reviews, for revocation, and so the process, as it were, of reconsideration and of making representations and of those being taken into account is positively built into the legislative scheme. My learned friend Lord Anderson made the point that the periodic duty to reconsider, you'll recall that, was removed by amendment by Parliament. Our submission in relation to that point being made is that it is accurate but irrelevant in the sense that it resulted in no material reduction in the safeguards, and that is because the Secretary of State, as I think one member of the court pointed out, still has the power to reconsider at any time, section 22 sub 2 of SAMBA. Moreover, and perhaps as importantly, the subject of the designation can request a reconsideration under the statutory scheme. And as you will recall from that provision, all that has to be shown is that there is some significant matter which requires consideration. It's not limited in any other way, so you can request, if you're the subject of the designation, a reconsideration as soon as something of significance occurs. And of course, if it might affect proportionality in the person's favour, then it would, by definition, be a significant matter. So you can challenge the original designation on all and any ground that you see fit, and if you're unsuccessful, you still have the right to request reconsideration, but simply on demonstration of a significant matter having arisen. And the reason why it's done in that way is obvious, and to some extent the reason why the original position was altered is obvious. What has occurred is that Parliament has made the judgment that there doesn't need to be the unnecessary and potentially burdensome automaticity of review, because it's entirely adequate for the purpose of securing proper protection and safeguarding of the designated person's interests, that they can request at any time, subject only to not being able to do so whenever they feel like it and as often as they feel like it. So there is some hurdle to be overcome, but as I say, if it's something which potentially affects proportionality, then by definition it would be a significant matter. So we invite you to note that in relation to the scheme of consideration under the relevant primary legislation. Lord Anderson also made the point, still on the same theme, that the appropriateness limb of Regulation 6 had been removed. And that again, we submit, is true, but again irrelevant, because it results in no material reduction in safeguards. And that is for the simple reason that, as decision makers are well aware, indeed as is clear from the actual decision making in these cases, decisions to designate an individual will interfere with their human rights and thus will need to be justified as proportionate. And Regulation 6, in the form that it was in, with its appropriateness test and considering whether it's appropriate in the circumstance of the individual case, simply reflected proportionality in that part that was removed. And indeed, I think that is a matter that Lord Pannick was kind enough to point out in the debate on the amendments in the Lords when they were brought forward. They were effectively irrelevant amendments because proportionality remained, and he was right about that. So the ability to mount the challenge on HRA grounds is entirely unimpeded in substance. The Secretary of State, as you saw from the papers that Lord Anderson introduced for you in opening the appeal, including the Secretary of State's officials operating under Cartona, have now considered the proportionality of Mr. Schvidler's designation on 3 separate occasions. At the time of the original designation, and the relevant reference for your note for that and for the proportionality assessment in the original SDF, as the form was called, is in supplemental bundle. These are all references into the Schvidler bundle. Supplemental bundle, tab 4 if you want the tab, page 31. That's the first occasion. The second occasion was in the course of the ministerial review. See for that purpose the proportionality assessment in the amended SDF at supplemental bundle, tab 7, page 106. And see also the consideration given to proportionality in the administrative review form at page 90 behind tab 6. And of course that second assessment, you will bear in mind, was carried out in the light of extraordinarily detailed representations that had been made by Mr. Schvidler, or more accurately on his behalf by Peters and Peters in July of 2022. And they responded to and considered the 36 annexes that were provided in support of the claimant's revocation request. And then, of course, thirdly, in the course of these proceedings, see the detailed proportionality analysis set out in Read 1, if you will forgive me, Read 1, paragraphs 60 to 86, supplemental bundle, tab 10, page 209, and the further reasoning in relation to proportionality in Read 2, paragraphs 32 to 42, supplemental bundle, tab 14, page 334. As I've said, at each stage of that process, the Secretary of State had regard to, took account of, and considered a large quantity of material, including extensive material and evidence provided by Mr. Schvidler. And that fact, i.e. the care and detail of that consideration, is relevant to the proportionality analysis. We cited below, it's not controversial now, so I'll just give you the reference, but we cited below a case called JT, indicated that the care with which the decision-making was undertaken was relevant for proportionality analysis. The case was called JT. I'll just give you the reference to the relevant bit in our skeleton argument below. So our High Court skeleton, paragraph 26, gives you JT and the relevant paragraph in JT. Our High Court skeleton, paragraph 26, core bundle, tab 10, page 141. And so we do not accept the attempt by Lord Anderson to portray the decision-making as in effect arbitrary and political. On the contrary, we submit the documentation makes absolutely clear the care and detail of the consideration of his client's case. The principal foundation for that submission in the facts appeared to be the attempt that he made to build on the subject access request documents. But my submission in relation to those documents is that they provide no support whatever for any such case. Indeed, on any fair reading, they indicate precisely the opposite, an appreciation of the need to consider the case for designation, both in detail and properly, which is precisely what occurred. From the outset in early March, when the idea of designation was floated, different departments were raising potential concerns. You'll recall the Treasury doing so, but more particularly, the Foreign Office did so and repeatedly made the point that the case was potentially complicated and needed to be thought about properly. And that is, in essence, precisely what occurred, as one sees from the periods of time involved. This was not, as it were, a rush to designation over the weekend, which I think at some point was at least implied by Lord Anderson. The initial proposal or possibility of designation, as you will recall from the SAR material, was around about the 6th or the 5th, I think, of March, so very early in March. And the decision, the first decision to designate, is not then taken until the 22nd of March. So some weeks thereafter, after the process which you have seen from the documents, and I gave you the references earlier. Nor is the implication or invitation to infer arbitrariness supported by the point, repeatedly made by Lord Anderson, that some grounds were put in but then altered or not then subsequently relied upon. All that indicates, we submit, is that the administrative review process was undertaken with real care. The mass of material submitted on behalf of Mr. Schvidler was considered, and those points had an effect. As it turned out, they did not touch the core of the case for designation, but that is a function of the facts. It is not a function of the inadequacy of the process, still less of arbitrariness in substance. On the same theme, and to deal with it quickly because we submit there is nothing in it, there was an attempt made orally to suggest that the absence of a policy, as it was put, the absence of a policy on designation or de-designation was an indication of, or I think Lord Anderson put it on the basis that it opened the door to arbitrariness. The initial point to note is that there was not a sniff of that point being run below, which is why you don't see it referred to in the judgment. But more substantively, it is a point in nature which is truly a prepared to wound but afraid to strike point. Lord Anderson was at pains to point out that he did not submit that it was unlawful not to have a policy. And it's entirely unsurprising that he should make that concession, particularly in the light of the Supreme Court's recent exegeses on policies in in that line of cases, the Lord Burnett, Lord Sales judgment, which I know members of the court will be familiar with. But the fact that he does not have the courage, as it were, to make the submission of unlawfulness entirely undermines the reliance that he placed on the only two authorities he took you to. I'm not going to invite you to go back to them. You'll remember one was B, the B case, B for Bertie, tab 16 of the authorities bundle at paragraph 43, and the second one was Lumber, as you recall, tab 23 at paragraph 34. But both of those authorities and both of those paragraphs identified, and I emphasise and underline, in the particular circumstances of the case that the courts were then considering, an obligation to have a policy. No doubt those cases will be extremely rare, and they may be two examples of them. They may be even more rare after the A decision, but that's beside the point. Lord Anderson asserts no obligation to have a policy. We submit that it's perfectly understandable why there was no such policy, given that each set of facts will need to be considered and is considered with care and with the many nuances that will exist between different cases, especially, it might be thought, at the stage of proportionality. It is therefore no indication of arbitrariness not to have a policy, and it doesn't open the door to arbitrariness not to have one. It opens the door, if anything, to the need intensely to focus on the facts of individual cases, which is precisely what the law requires. We note finally in relation to this point that it's entirely unclear what it is said the policy that didn't exist should have said. So that's the first of the initial points, careful consideration, not undermined by the various ways in which it was sought to suggest that arbitrariness had either crept into the room or was in the room waving its arms around. The second initial point is that there is no challenge to the lawfulness of the designation criteria. I don't go back to them because the court will be very familiar with them by now from the judgments and from the helpful opening that you have received from both in both cases. The designation criteria for Mr. Schvidler's purposes are contained in Regulation 6, as you recall, and they are broad. And they are broad for good reason, that we submit, although that may not matter because the fact of the matter is that Parliament has chosen to enact them. They set up the hurdle of reasonable grounds to suspect that a person is an involved person. You see that or saw that from Regulation 6(1)(a), cited by Mr. Justice Garnham in the judgment at paragraph 46. Call on board page 86 if you want it. And that test, as you will recall, was derived or is derived from the primary legislation, section 11, which the judge cites or describes at paragraph 38. The nature of that test, it's not an issue in this appeal, but if you wanted reminding of what that test brings with it and what it doesn't bring with it, that was the subject of some detailed consideration by Mr. Justice Jay in the Synesis case at paragraphs 75 to 78, where it was in issue. If you want that reference, it's Authorities tab 40, page 1909. So it's broad for that reason, reasonable grounds to suspect, and it's broad because it's set up so that involved person is broadly defined in Regulation 6 sub 2. I wanted to pick up one point in relation to these regulations, or perhaps two short points when dealing with the unchallenged designation criteria. The first of them is Regulation 6(6). Maybe we have to go to the authorities for that. So tab 4, just so you have the form of it, or can remember the form of it, of the authorities bundle. Page 125. And I go here because Lord Anderson sought, as it were, to tee up a debate around what this meant. And our submission is pretty clear what it means. It provides that being associated with a person includes obtaining a financial benefit or other material benefit from that person. It's one of the limbs, as it were. And our submission is that it doesn't follow that association is limited to either of the specified matters in A and B. And we make that submission for the pretty obvious reason that on its natural and ordinary meaning, includes means includes. It's expressly non-exhaustive. And that is a common definitional section which is not designed to set limits or to be exhaustive, otherwise you wouldn't have dreamt of using the word includes if you were the parliamentary draftsman or the draftsman of these regulations, but rather to put the identified elements within the definition, i.e. 6A and B, beyond doubt. The high point of the submission on interpretation appeared to be, why include immediate family? With the definition which is expanded, as you see at the top of page 126. And the answer to that question, that rhetorical question, is for precisely the reason I've just identified, to put beyond doubt that those members will indeed qualify and fall within the associated with definition in these regulations. Lord Anderson said, well, you'd have a bit of a job if you were trying to persuade someone that a great grandson should be covered. To which my answer is, well, that rather depends on the facts. It might perhaps depend on whether the great grandson was in fact working for his great-grandfather, the oligarch. But it would certainly depend on the facts. Nothing is excluded. But the core point is the obvious one, which is that the relevant way in which it's been drafted is non-exhaustive. And the reason this may be important is because when we get to the facts, which I'm going to come to in a moment, on the natural meaning, we submit the concept of association encompasses Mr. Schvidler's admitted, and I'm going to use words as he has described them, quote, long-standing personal and business relationship with Mr. Abramovich. So those are the legislative choices that have been made about the extent and reach of the criteria for designation. But that's the first of the points I wanted to pick up in relation to those designation criteria. The second of them is the associate of an associate point. That is not being relied upon here as a ground for designation. And so I don't take any position on interpretation on that question for that reason. But even assuming that that is the correct reading of the regulations, in other words, you can't build in a criteria that says associate of an associate, but one needs to be clear about what the effect of that would be. It would mean that you couldn't rely on a person being an associate of an associate for the purpose of meeting the designation criteria. But it only means that if you can demonstrate association by other means, plainly falling within the designation criteria, it would obviously be potentially highly relevant to proportionality that the person of whom the designated person is an associate might be someone of real influence over the decision makers or in relation to the decision makers in Russia, e.g. Abramovich and Putin. So that's what we say about the meaning in relation to that and the true effect of it. We do not submit that it would be to unravel or undermine the purpose of the regulations, to recognise that even though the designation criteria are set up in that way, that sort of potential to influence might not well be highly relevant at the proportionality stage. Can I then turn to the facts relating to the involvement of Mr. Schvidler? And I start here not merely because a person has to fall within the designation criteria for the domestic power to arise, but also because the basis on which he is involved provides an important part of the personal circumstances of the individual and of the facts of the case, alongside, of course, hardship and impact and everything else that feeds into proportionality. There's never been an issue that the basis for for designation that he was involved in obtaining a benefit from or supporting the government of Russia through working as a non-executive of EVRAS. See the judgment of Mr. Justice Garnham, paragraphs 56 and 64. He did and continues to seek to put in issue the basis of involvement founded on his association with Mr. Abramovich. There are three particular bases of challenge to the proposition that he received any financial or material benefit from Abramovich, or that he was otherwise associated with him within the meaning of regulations 6.2d and 6.6. In particular, he asserts before you, as he did before the judge, firstly, that any remuneration received from Sibneft or EVRAS was received from those companies and not from Abramovich. Secondly, he does not accept that Abramovich was himself involved in obtaining a benefit from or supporting the government of Russia by owning or controlling, directly or indirectly, EVRAS and its subsidiaries. And thirdly, it's not accepted by Mr. Schvidler that his long-standing close personal and business association otherwise constitutes association within the meaning of the regulations. Just to give you some responsive references on those points, if I may, to start off with, and I'll come to them in a little bit more detail in a second. those claims or non-acceptances, as it were, are picked up and dealt with and responded to, especially in Reed 2. So Mr. Reed's second statement. They are dealt with in the judgment of Mr. Justice Garnham between paragraphs 98 and 105, with the upshot being that the judge concluded that both those bases of designation, including the association one, are made out. See paragraph 105 of the judgments. And we've dealt with it in our skeleton before you between paragraphs 26 and 36. Just to pick up Sibneft first of all, principally in our skeleton at paragraph 29, Mr. Schvidler has described Sibneft as, quote, Mr. Abramovich's company. Supplemental bundle, tab 5, page 38. He was remunerated, that's Mr. Schvidler was remunerated as vice president and later as president of Sibneft, and what he described, it might be thought accurately, as a generous severance package following its sale in 2005 of $10 million. Supplemental bundle, tab 5, page 41. And although that benefit was, it is true, received in 2005, it is clear from his own evidence that it has had lasting significance for the development of his subsequent business interests. See for that purpose, Reed 2, paragraph 15, supplemental bundle, tab 14, page 329. And it's clear from Mr. Schvidler's own description of his, quote, business connections that his role at Sibneft arose out of a pre-existing friendship and association with Mr. Abramovich. See for that purpose paragraph 17 to 20 of the 14th of July 2022 letter written on his behalf by Peters, supplemental bundle, page 37. So we submit that his remuneration is properly characterised as a financial material benefit truly obtained from Mr. Abramovich, and that in essence was the judge's reasoning. See paragraphs 99 to 100, and we submit the judge was entitled / right, I'll come to abortion services in due course, to reach that conclusion. That's Sibneft. Evraz, our skeleton paragraph 30 deals with that. The Secretary of State relies on Mr. Schvidler's role as a non-executive director of Evraz in two related respects. He was Mr. Abramovich's nominee director. He acted as nominee director on the board. That's confirmed, amongst other things, by an exhibit to Mr. Schvidler's own evidence, a letter from Evraz to OFSI, OFSI, overseeing body, dated the 11th of March 2022, supplemental bundle, tab 2, page 17. The claimant suggested that his identification as Mr. Abramovich's nominee director was a matter, as he put it, of formal description and does not reflect any actual action taken by Mr. Abramovich at any time. But the difficulty with that is that his own description of events in his second statement, at paragraphs 69 to 75, supplemental bundle, tab 13, page 262, indicates that his association with Abramovich was essential to his obtaining that role. And for that reason, and as explained in Reed 2, paragraph 18, there are reasonable grounds, as Mr. Reed puts it, to suspect that but for his association with Abramovich, Mr. Schvidler would not have been in this role and would not have obtained the resulting financial benefits. Page 330 of the supplemental bundle for that paragraph in Reed 2. That's the first significance of it, nominee director of Abramovich. Secondly, he was a director of a company jointly owned by Abramovich, for the reasons set out in Abramovich's SDF, which is in core bundle behind tab 17 at page 226, there are reasonable grounds to suspect that there is a joint arrangement between Abramovich, Abramov and Frolov, such that they can each be treated as holding directly or indirectly more than 50% of the shares or voting rights in Evraz for the purposes of Reg 7.2, which, as you will recall, has to be read together with paragraphs 3 and 12 of the schedule. Remember that balance. In short, the company regarded Abramovich, Abramov and Frolov as concert parties and therefore controlling shareholders for the purposes of its obligations under the FCA handbook and listing rules.
That doesn't really matter if regulation 7.2 is satisfied.
Yeah, it doesn't. Well, I think that's the short and simple point. But if you wanted more detail on that, see read 2, paragraphs 19 to 27, and our skeleton in this court, paragraph 31. But as my lord points out, a more straightforward route to establishing financial benefit is simply that Abramovich appointed Mr. Schvidler as his nominee director on the board of Evraz, for which he was substantially remunerated. So that's more than enough. But we've made the points we make in our skeleton of paragraph 31 in relation to all of that. So that's Evraz, and then the final bit of association, as it were, or involvement, is association beyond the receipt of financial benefits. And I've substantially touched on that already and made my submissions about that. It's really based on Reg 6.6 and how you approach that as an issue. And I submit that if you are a long-standing friend and business associate in the way that Mr. Schvidler evidently is Mr. Abramovich, that is more than sufficient to establish association in any event. You don't have to cram yourself into the non-exhaustive identified definitions in 6.6. But we've dealt with that, if you want the detail of it, in our skeleton before you at paragraphs 33 to 36. So the conclusion of all of this is that the judgment of Mr. Justice Garnham at 101 to 104, which contains the substantive reasoning on this set of issues, was right. The starting point for proportionality is therefore that Mr. Schvidler is an involved person for the purpose of the 2019 regs and satisfies the lawful designation criteria that Parliament has laid down. So he falls within the class of person in respect of whom Parliament has lawfully determined there is at least some legitimate public interest in designating. And that is a factor, we submit, which, although of course not conclusive, as the judge records, is a matter to be accorded some weight. Before turning to proportionality directly, just a little section, if I may, on the facts relating to impact on Mr. Schvidler. If we're dealing with the bases for his designation, then better deal with impact here. Principally referable or principally important when we come, as I will in due course come back to, the fair balance aspect of proportionality. I want to just make some short points in relation to licensing. As you're aware, SAMLA makes, that's the primary legislation, makes provision for a licensing regime pursuant to which conduct which would otherwise constitute a contravention of financial sanctions prohibitions is exempt from those prohibitions. And in broad terms, that regime draws a distinction between general licenses and specific licenses. General licenses are issued by OFSI, OFSI, to allow multiple parties to undertake an activity which would otherwise be prohibited under the financial sanctions legislation without the need for a specific license. So that's what the general license normally does. And then specific licenses are granted on an application to OFSI by an application and the provision of appropriate information by the designated person, for example, to meet needs or education and so on. below, a series of complaints were made by Mr. Schvidler about the operation of that system. Of course, the overarching answer to all of them is that if that system is not working as it should do, then it's open to someone to challenge either the inactivity or the wrong-headed, if that's the way they view it, decision-making that they made. But those complaints that were made below were dealt with in some detail by Mr. Reed in his evidence. Reed 1, paragraphs 98 to 101 deals with them in particular, supplemental bundle, tab 10, page 221, and notes, amongst other things, in those paragraphs, that Ofsey was at that time awaiting further information from Mr. Schvidler in relation to 3 outstanding licence applications, including an application in relation to the basic needs of the family, to which no response had in fact been received from Mr. Schvidler. See paragraph 100 of Reed 1. Mr. Reed also notes that Ofsey had extended its approach in respect of general licences, issuing 50 general licences since the invasion of Ukraine, including general licences for legal fees, payments to utilities companies and so on, from which Mr. Schvidler has benefited. But perhaps in the light of the way in which the material was presented in opening, it may be worth just referring back to Mr. Schvidler's own evidence in relation to this. If you go to supplemental bundle, page 184, please. This is in his witness statement. And it deals with basic needs and maintenance, food and all of that. And you will see what is said in particular at the top of page 184 in paragraph 77. So he hasn't experienced any difficulty meeting basic day-to-day needs, is his own evidence. So that's the short point in relation to basic needs, but he also had and has the ability to make applications for specific licences, but in order to do so, he has properly to engage with Ofsey, which at least at the point of Reed 1 he hadn't been doing. In relation specifically to his children's schooling, Reed 1, if you still have that bundle to hand, it might be worth again just going to this. Reed 1 behind tab 10 on page 223. Paragraph 104. And you will see what is there said about the children's schooling. In summary, that no one from FCDO or Education have issued any directions requiring schools to exclude designated persons or their dependents, that Mr. Schvidler would be entitled to make an application to Ofsey for a licence to authorise payments, including school fees, and that he would in any event have had the state school option.
So James, can I just ask you to make sure I've understood correctly
yes.
your position? The general licences you referred to, they're not issued in respect of any particular designated person. That's just.
My understanding is that they're just general, in the sense of applying to multiple people.
Yeah. So when it comes to having to apply for a licence, for example, to cover school fees,
It's specific.
but that's specific in the sense that the individual designated person has to make an application.
Yes, that's my understanding. I'll double check that that's
what
right.
I thought, yeah.
But that's, I think, the way it works. And the point that's being made here is you could have done so. Obviously, if you're going to engage in that process, you have to engage properly in that process. And if proper questions are asked, then you have to respond to them.
But in respect of things like legal fees, I think you said, that there is, as it were, a sort of sectoral licence, so that you don't have to make a specific application.
There is.
School fees, there isn't.
Yeah, school fees, I think, is specific, perhaps for understandable reasons. And just to complete the picture, and so you have all the references in one place, if you would, just to note, please, there were the various other complaints that he makes in relation to licensing, which mostly relate to his yacht, which is called Le Grand Bleu. That is dealt with in Mr. Reed's second statement at paragraph 42 in particular, responding to those complaints. That's supplemental bundle, tab 14, 1-4, at page 339. I wanted to turn then, if I may, with that introduction, to proportionality. Quite a drum roll, but jolly nearly. Proportionality, and in particular the approach to proportionality in principle. And I start with that, and I'll try and make some progress with that before 4:15, if I may. The basic approach is clear and uncontroversial in terms of the structure, a very well-known structure of the analysis. You can take the four-stage test contentedly from Bank Mellat, cited by the judge in paragraph 80 of his judgment. I wanted to start with perhaps what is the most, if I can put it this way, politely fluid area of case law in relation to this issue, which is what is the correct approach for you as an appellate court to adopt in relation to a challenge to proportionality. And we have given you in our skeleton argument, I just invite you to take it up. Paragraph 14 is the one I want. It's in core bundle for Schvidler, page 48, paragraph 14, 1-4. And obviously a lot of this is going to turn on what the latest statements from Lord Reed in abortion services mean or imply, as it were. But it is quite important to come at that issue, bearing in mind and recognising, of course, that Lord Reed says in relation to some of this at least, well, may not want to pay too much attention to that because things may have moved on. I think in relation particularly to something that Lord Campbell might have said. So there's a bit of a note of caution, but at least see how you get to abortion services. And you get there through a pretty well-established set of rules set out in the CPR 14.1, well-established the wrong test, and a description of what that means in the R case.
Well, that's the one that...
That's the one that he queries. Yeah, that's Lord Carnworth. So I fully accept that marker. But that's at least what Lord Carnworth said for the Supreme Court in that case. And then you've got that in quite a number of other cases, including the B case, if one's focusing principally on Court of Appeal and Supreme Court. Look at 14.4. Effectively saying it doesn't matter if you're under the HRA, you're still applying the wrong test. And then Z, 14.5, again I think the subject of some comment by Lord Reed in abortion services. And then this court, and again ordinarily it will be binding, but it depends on whether or not you take the view that abortion services has altered the law at a higher level, so I'm not going to hang my hat on that, but you see what the Court of Appeal concluded in Friends of the Earth. That was to do with the ivory ban, as you may recall. That 14.6 does not re-perform the assessment, but considers whether the reasoning of the judge below was justified. Then the point that the wrong standard is in any event capable of being applied flexibly and adapted to context. But the point
is this Ziegler?
This is Ziegler.
Yeah. Again, we may have to be slightly cautious because Lord Reed has something to say about
Ziegler. He does. And we're going to the only one you'll be delighted to hear. The only one I'm going to go to is abortion services. Right. But just so you see how we get there and what is being said by the court in Ziegler. And then abortion services.
Just
So-
before you
Yeah.
leave that, one thing we do derive from the quotation you have helpfully set out at 14.7 is that a proportionality assessment is in part a factual assessment
Yeah.
and in part a normative assessment.
Yes.
And that may, I don't know, but this may have a bearing on how we are now properly to treat the role of the appellate court in the light of abortion services. Because if one just takes by way of example the judgment of Mr. Justice Garnham in the present case, which you showed us a moment ago, clearly there are parts of that judgment where the judge looks at all the evidence in front of him and reaches certain, I think you would say, findings of fact, findings of primary fact. Is that right? You would
Yeah.
say, for example, when he was looking at what the evidence entails as a matter of association, etc.
Yeah. It may make a difference, and it may be, however, that even that is not conclusive.
Right.
I mean, it's not in the bundle. You may recall that Lord Sales, once upon a time, gave an Alba lecture on this very subject,
Yes.
and his thesis, in essence, was that this was multifactorial, and it all slightly depended what you were dealing with. And the punchline of the submission I'm going to make when we get to abortion services, again, you won't be surprised to hear me say, is that in abortion services, Lord Reid appears to be at the very least drifting towards that position, because he drew what appeared to be a relatively clear distinction, at least in his mind, perhaps not hermetically sealed, because there may be some cases which are more about individual facts but have big knock-on effects. One thinks of Elan Kane, for example. But that there is a distinction between a proportionality challenge that goes to challenge the proportionality, for example, of a particular legislative regime or policy as such, on the one hand, as compared to the application of proportionality, which may come back to your fact versus normative assessment thing, where it's more about the assessment of individual facts.
It may do, but Sir James, certainly speaking for myself, in not necessarily now, but in due course, I would find it of assistance if you could help us with this possible, but possibly incorrect way of looking at things, which is why I need some help. Could it be said that when it comes to the establishment of primary facts, that is still the conventional function of a first instance court or tribunal, and that an appellate court such as this ought not to interfere with those kinds of findings? What happened? You know, was he or was he not in a relationship? Did he receive $10 million or not? Now, as Lord Reid says in Abortion Services, proportionality is not a question of pure fact, at least if that's because it involves having established the facts,
Value judgment.
a value judgment, having established, and Lord Reid makes the point that often the facts are not in dispute. But what I'm asking about is really this, that if they are in dispute, what's the role of an appellate court? Is it still the traditional one that we would not usually interfere, but we might, for example, if there was no evidence on which a finding of fact could properly have been reached and things of that sort. And as I say, don't please answer this now.
Well, I'm on it.
But in due course, could it be said that even if that's right in relation to questions of primary fact, that when it comes to the overall value judgment of proportionality, even in an individual case, in other words, not a challenge to legislation or a policy, but just in an individual case, like Mr. Schvidler's case, could it be said that actually it is for the appellate court
To adopt something more interventionist.
Yeah.
My Lord, you could, and I think my answer of principle to that is at least that.
Right.
I mean, I'm going to make a slightly broader submission, which is that although it's not entirely pure, the distinction which is being drawn in abortion services does draw a distinction between challenges which are challenges in essence to a scheme, which sometimes happens.
Yeah, yes.
I can think of examples. SC is a classic example, the two-child rule. There are other examples we'll see.
Yes.
Or a policy. You challenge the policy itself as disproportionate.
So you can challenge legislation.
You can challenge legislation.
As in Belmarsh.
As in Belmarsh. You may have to surmount a relatively high hurdle following Christian Institute, but you certainly can do that. And if you are doing that, then you're much closer to the territory where the appellate court has, as it were, free rein for a much more interventionist approach. So the way I might go a little beyond where my lord was is in the distinction between that sort of case on the one hand and the case on the other hand, where what you are effectively doing is to examine proportionality as an appellate court in all its ingredients, recognising that it's fact and evaluation, or fact and normative, between that sort of case, challenging the policy, challenging the law, as compared to individual circumstances, where the test remains, for both fact and evaluation, the wrong test. So you don't just simply come at it afresh, but it's slightly bedevilled with language and how flexible is wrong and where the dividing line precisely lies.
And it's very unusual in judicial review for the court to be deciding facts,
For
contesting
itself.
facts
Certainly.
for itself, because the facts are assumed in most cases.
In many cases that's true. In some cases it isn't, particularly human rights cases.
Exactly.
Back to Al Sweeney.
My lord is of course right, but I think the major exception to that, which has now emerged, is in human rights cases where it's necessary. Sometimes it's not necessary, sometimes they're not in dispute, and so on.
So really the debate between us perhaps is I entirely accept and agree with the proposition that if what you're looking at is a challenge to a factual finding, then there doesn't seem any terribly good reason in principle at all for adopting anything other than the wrong approach, wrong in inverted commas. But I slightly broaden that out to include those cases where the nature of the case is a challenge to the application of proportionality to individual facts in individual circumstances. Now, as I say, the line is a little blurred, and there may be some scope for moving closer towards Lord Sale's position and saying, well, even that is a bit simplistic. You need to look at all the circumstances and work out precisely where you lie, because one recognises that there may be cases, and Lord Reed refers to a couple of them, I think, which one of them I think is Bank Mellon, the other one is Elan Kane,
Yes.
in which you are dealing to some extent with the application of proportionality to the individual case, but it evidently has, pretty significant impact akin to a challenge to policy or to legislation. Take Elan Kane as the example. It was ultimately about the proportionality of the interference with Article 8 rights not having X on the passport for Elan Kane. But the logic of her winning or losing on that proportionality argument was plainly capable of systemic impact, to put it at its lowest. It'd be jolly difficult to see how Elan Kane could have succeeded in saying I get X on the passport, and all other non-binary people wouldn't have been able to pile through that door. So there may be difficult cases on the boundary where the multifactorial approach that Lord Sales was advocating is a bit more attractive. But I think my answer in principle to my Lord is, yes, please bank the fact bit, but I also put in that same box fact plus evaluation if you are dealing with a case in which proportionality is being applied to individual facts as compared to the application of proportionality to challenge a policy or a piece of legislation.
So where were the contested facts in this case that the judge found? I thought there was no attempt to cross-examine any of in either case, no attempt to cross-examine.
Well, my Lord, there was no attempt to cross-examine, but the judge still looks at all the underlying points and
relies on certain facts.
Relies on certain facts and then infers other things from those facts, which might be thought to be factual inferences.
But this makes it
it makes it very complicated if you go down the pure fact versus evaluation thing.
I mean, I come back to simplicity. I balk at the idea that we don't know what we're doing and are applying different tests to different parts of the appeal, particularly in a case when there's no fact-finding in the traditional sense of civil justice, where people go in the witness box and somebody says something and is disbelieved and blah blah. Of course, you apply the wrong test. Of course.
Oh yes. Well,
but this is a completely different situation. This
is
is JR, where the evidence is taken from the decision maker pretty well at its face value, and okay, the judge may rely in undertaking the balancing exercise required for the proportionality evaluation. But I find it incredibly difficult to say that is therefore something we either can only do partially again ourselves,
or you have to cut it so fine in every case and work out where the distinction between evaluation and fact lies.
You know, where I'm coming from here, and again, I'm speaking only for myself, and I always accept my ignorance in this field of law. But the fact of the matter is that I would be looking to see first whether the judge made an error of law. And the error of law that Lord Anderson identified several times is in paragraphs 91 and 92, where he says
Yes.
that he was limiting himself to asking whether the decision was one properly open to the executive.
Yeah. But I think we're all agreed that if it's error of law on that basis, you're in the game on any
Open season.
open season.
Because we would remake in that situation.
Because you would remake.
Just
or-
start again, so we can.
it-
We're the first instance tribunal.
Exactly. This was all the debate that we had in, I dare to, hardly dare say the word Rwanda, but this was all the debate that we had in the Supreme Court in particular about how correctly to approach all of that. I'm not going there. I promise I'm not going there. But error of law, it's open season.
Yeah.
The difficulty with the purity, and I quite understand why my Lord Justice Singh comes from where he does on fact versus evaluation, because they're different roles, and traditionally in relation to fact finding, one accords more respect to the decision maker for primary decision.
The
first
difficulty in
instance.
this case
Yeah.
is the margin of appreciation, where you have a four-pronged test, and the margin of appreciation may have a different, may be at a different level for each aspect of the test. So Lord Anderson and Mr. Bethel say, okay, you haven't got any closed material, it's all there, you can decide it, you don't give much, give much deference to
Yes.
the decision maker. If you've got closed material, you might. If it's a political decision, you might. So what we're being told is that of all those four tests, each one requires a different level of deference to the decision maker.
Well, or it may do. I'm not going to get into that debate too early, because I mean the closed material thing is a complete red herring. I'm going to submit.
Well,
But
I'm not
if
saying.
it's for no, I'm not. I know.
No.
So you're just illustrating, but
But what I'm saying is, if you've got that uncertainty with your four tests, and you've got the factual versus legal
Becomes very
uncertainty, you really are sentencing every first instance judge to an impossible task and an appeal here in every case. And you know, we've been thinking how ridiculous it is that there are so many different formulations of what the proper exercise is.
Yeah.
And we would be helped, and I see the time, by your submissions, both sides, by the way, if they wanted to, as to what the proper exercise on appeal is in a proportionality case. Because, I mean, obviously, we all agree if the judge got it wrong, open season.
on law.
On law, of course, the judge got it wrong on law.
Yeah.
No, in fact, it's a different test, you know. But I think, you know, we've been looking at Ziegler, we've been looking at abortion services, we've
Yeah.
been looking at Bank Mellat, and so on. But there's an imperceptible change as you accept it in your submissions. And I think it would be very helpful if this court, in this case, were to be able to say, this is the way you approach it, and this is, for a first instance judge, something you can rely on for a change.
My submission, just to give you the submission, my submission is that the correct approach in principle is that if you are dealing as an appellate court with a case that involves a challenge on proportionality grounds to individual decision making, then the correct approach for the appellate court is the standard one. In other words, it has to be demonstrated that the judge below was wrong with all that implies. And it is not for you simply to put yourself into a position of first instance judge and retake that decision. That's my primary submission.
So that abortion services does not apply to a case like this.
Abortion services does not, the reasoning in abortion services applies where the proportionality challenge is to a legislative scheme as such or a policy as such. Now, the only wrinkle in that clear distinction is the reference to Bank Mellat and Elan Kane at the back end of paragraph 31 in abortion services. But I submit that those cases, particularly Elan Kane, are examples of cases in which the logic of the appellate court's decision would necessarily apply across a very wide sphere of action, and therefore is akin to a challenge to policy or legislation. There is the alternative which Lord Justice Singh put to me, which is you then do it on a much more complicated basis. It's multifactorial, and fact is one thing and evaluation is another, but that does require you to draw some nice distinctions.
Well, I think
that may make it complicated, but that's my submission.
for my part, I would appreciate using some part of tomorrow to bottom out precisely how that comes out of the authorities,
Yeah.
and on Mr. Lord Anderson's reply, how he says we should undertake this exercise,
Yeah.
because for my part, I find this the idea that you have to apply a different test in each case depending on the factual component very difficult.
But at the very least, the submission I've just made at least has the advantage of simplicity, because you can tell what the nature
Yes,
of the claim
but
is.
it may not be right.
It may not be right. I do understand that.
And I mean, you know, I do like being right, so I try.
I'd almost never make a submission that isn't right. Abortion services is really the authority I'm going
Can
to
I write that down?
Yeah.
Almost never make a submission.
Can I invite you overnight, if you would, or if you have a moment, just to read paragraphs 31
Yes,
through to 34 of abortion services, page 2015.
we really have.
You already have. Well, those are the key paragraphs.
We really have prepared for this case.
Yes.
James, it may come as a great surprise.
Well, you can make of them what you will, really, but those are the paragraphs in which Lord Reed sets out what he
That's
sets
what
out,
he says, yeah.
with its limits.
Yeah. Okay. Well, thanks very much. I mean, that's helpful. And thanks to everybody for really getting on with submissions today. I think we appreciate it and feel we're in a much better position at the end of today towards finishing this case at 4:15 tomorrow and not a minute later than we were yesterday. So thank you. How long do you plan and your team to give the replies?
Well, we'll try and make sure it's an hour.
An hour between them?
Yeah.
Well then,
And
Lord Anderson and Mr. Bethel, you better go outside and take your gloves off and see how you're going to split that up.
Yeah. I mean, I give them that not in a spirit of ungenerosity, but
Well, they did take.
they had jolly nearly 2 days before I got to my feet.
Okay, good. But can we try and push that back to 3 o'clock?
Of course.
Thank you.
All right.